All right, go ahead.
All rise. The United States District Court for the Northern District of California is now in session. The Honorable Judge Henderson is presiding. Please be seated and come to order.
Okay, good afternoon, Counsel. Are you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Okay, would the prosecutor give your opening statement?
Before that, Your Honor, a couple brief housekeeping matters, if you don't mind.
Certainly.
Do you have a preference if we stay seated or should we stand for our opening and closing?
I would stand just for the practice of it. You will normally have to do that.
Okay. And would you like us to ask when we approach ask to approach the witness when we approach them?
No, you may approach.
Okay. Thank
Your
you,
Honor, we would also like to request constructive swearing in of witnesses and constructive sequestration.
Okay, granted.
Thank you.
Your Honor, this is the defense. May we also ask that if there are any technological difficulties, that time be paused?
Yes, we will pause time. I'll call a recess and we'll take care of that and get back on the record. Okay, are we ready to begin?
Yes, Your Honor.
Okay, let's begin with the opening statement of the prosecution.
Okay. Good evening, Your Honor. Hadley Rood for the prosecution.
Okay. You may proceed, Counsel.
Thank you. Members of the jury, money shouldn't buy you everything. We all know how the saying goes, that it can't buy you happiness, but it also shouldn't buy your child's way into the college of your choosing. But today, my co-counsel, Julia Brandt, and I are going to show you that that's exactly what the defendant, Mr. Smith, tried to do. You'll hear from Pat Matthew, the college admissions consultant Mr. Smith paid to carry out the plan of getting Jenna, his daughter, into college. But first, I want to walk you through that plan, from its formation to how it was carried out to its aftermath. And at the end of the day, the evidence will show that Mr. Smith tried to use his money to trick top-tier schools into thinking that his child was someone that she wasn't. First, to the formation of the plan. This all started back in December of 2015, when Mr. Smith's youngest daughter, Jenna, was applying to colleges. Her dream school was Berkeley. The problem was that her test scores weren't high enough to get her into this and other top-tier schools. With this consideration in mind, Mr. Smith reached out to Pat Matthew, known as the person to see, about getting wealthy children into top-tier colleges. Today, you'll hear about a correspondence in which Mr. Matthew warned Mr. Smith that his services could cost 6 figures. And you'll hear about Mr. Smith's response, that price is not a concern. Mr. Smith thought he could use his money to buy him and his daughter everything. So, on January 2nd of 2016, Mr. Smith and Mr. Matthew met at Mr. Smith's Newport Beach home. It was there that they came up with the plan that was sure to get Jenna into the colleges of her dreams. There were 2 parts to this plan. Step 1 was that they had to fake Jenna's test score. She had struggled on the PSAT, getting only a 1080 out of a possible 1600. That score was going to have to change. Second, they were going to have to fake Jenna's athletic profile. She wasn't a student athlete, but they were going to make her look like one. That was the plan from the beginning, and that's what Mr. Smith paid Mr. Matthew to do. Because today you'll hear that at the end of that meeting, Mr. Smith had no problem whipping out his checkbook and writing 2 checks for a total of $150,000. So, there you have it. Mr. Smith using his money to buy his daughter's future. Now, how did they carry out their plan? Well, step 1 was to get Jenna a better test score. To do this, Mr. Matthew had a psychiatrist, Dr. Carla Gebbo, who was also recently arrested regarding these allegations, write a letter diagnosing Jenna with ADHD. Now, in this letter, Dr. Gebo states that she used written observations and physical observations to come to her conclusion, a battery of tests. But Mr. Smith has said, and will tell you today, that Jenna only ever spoke to Dr. Gebo over the phone. Mr. Smith saw the letter. He knew they'd only spoken over the phone, but he submitted the letter to College Bound, the SAT test administrators, anyway. He did this so that Jenna could get her test center changed to the one Mr. Matthew owned in Newport Beach. And from there, Mr. Matthew's associate could change Jenna's test answers to raise her score to something that could get her into Berkeley. In the end, she got a 1480 on her SAT. A 1480. That's in the 98th percentile of all test takers. And that was the score that was submitted to the colleges in her applications. But remember, members of the jury, that was only step one. Step two of the plan to get Jenna into college was to turn her into a golfer. Now, has Jenna ever played golf? As Mr. Smith will tell you, no, she hasn't. She never has. So to make her look like a golfer, Mr. Matthew bribed the golf coach at the University of Scenic California with $30,000. More money changing hands to buy Jenna's future. Because of this bribe, the golf coach signed a letter and made a phone call recommending Jenna to the University of Scenic California's admissions program. Not only this, but Jenna's resume that was included in applications to all three schools had an entire section labeled golf team, where it talked about her golf team accomplishments and said she'd been the captain of her high school golf team. Keep in mind, folks, that Jenna had never played golf. Mr. Smith knew this, Mr. Matthew knew this, but they submitted the resume anyway. Now, what happened in the aftermath of this plan? Well, members of the jury, the plan worked. Jenna got into all three schools that she applied to. She's even a sophomore at Berkeley right now. And today, you're going to hear that Mr. Smith didn't forget to thank Mr. Matthew for helping him get Jenna into these schools. He sent Mr. Matthew a Cal sweatshirt and $5,000 in cash after Jenna had been admitted to Berkeley. $5,000 after all the money he'd already paid to get Mr. Matthew to help him in the first place. Now, members of the jury, no one is contesting the fact that Mel Smith loves his daughter. Of course he's a loving parent. Of course he wanted to help her get into a good school. That's not what this case is about. Because when love means spending $150,000 plus tip to buy your child's way into college, that's not love at all, members of the jury. That's fraud. Now, Mel Smith also claims not to know about the fraud, not to know that Pat Matthew, to whom he just paid $150,000, was orchestrating these documents for Jenna to submit to the colleges of her dreams. But I want you to remember that Mel Smith loves his daughter. Not only is he a loving parent, he's an involved parent. To use his own words, a very involved parent. Today, the evidence will show that this very involved parent was willing to spend $150,000 to buy a test score and an athletic profile. Then, he gave Mr. Matthew $5,000 in cash after their plan worked. How does that square with Mr. Smith being in the dark about Jenna's college applications? The answer is clear. It doesn't. Now today, members of the jury, you're going to have an opportunity to see what all that money bought. You're going to hear from Mr. Matthew, who will walk you through the plan I just described. And you're going to hear about the results of that plan. The fake letter from the psychiatrist, the fake test score, the resume, and the recommendation letter. And at the end of all of that, my co-counsel, Julia Brandt, is going to come up here and ask you to find the defendant, Mr. Smith, guilty of the crimes alleged. Money shouldn't buy you everything. And today, you can tell Mr. Smith that it doesn't. Thank you.
Thank you, counsel. Defense, are you ready to make your opening statement?
Yes, Your Honor.
You may proceed.
Members of the jury, there is a cheater in this case, but that cheater is Pat Matthew. That cheater is not Mel Smith. Pat Matthew is a college admissions coach. And today, you will hear how Pat Matthew ran a sophisticated operation to cheat our college system. Pat cheated for more than 15 years. He cheated colleges, he cheated the community, and he cheated hardworking students out of academic opportunities. He cheated so much that he faced 220 separate criminal charges and up to 800 years in prison. But Pat won't pay for his crimes because Pat found an exit strategy. Pat is making our client, Mel Smith, his scapegoat. Members of the jury, in this trial, I want to share with you 3 things that show our client, Mel Smith, is not guilty. The first, Pat Matthews' testimony is the only piece of evidence connecting our client to fraud. Second, Mel hired a legitimate admissions counselor for his older daughter, Cher, and it worked. He had no reason to cheat, knowing that Jenna was just as talented as Cher. 3, Pat Matthew is a professional liar, and he has a lot to lose if he doesn't say that Mel knew about the fraud. We all know Mel Smith, the Mel Smith of Hollywood, the actor whose talent wins him award after award. That's hard work and merit that you could never fake. But today is not about Mel Smith, the actor. Today is about Mel Smith, the father. Mel Smith has raised 2 daughters, Cher and Jenna, with his partner, Andy. He loves his daughters. He never misses Cher's quiz bowl games or Jenna's mock trial competitions. Even with his busy filming calendar, he flies from wherever he is to be present at their competitions. Because Mel wants to show his daughters, hey, I love you and I believe in you. When it came time for Cher to apply to college, Mel did what any father with his means would do. He got Cher an admissions coach, someone who knew the college application system, who could help her prepare for the tests. And after working hard and following her coach's advice, Cher got into New York University. No one denies that Cher got into college from her own merit and that Mel supported her as any loving father would. Now, when it came time for Jenna to apply for college, Mel did the exact same thing. He got Jenna an admissions coach, someone who could help her prepare for the tests, who could help assess why she was struggling on the PSAT in particular. That person was Pat Matthew. Today, you will hear how Mel heard that Pat was the best admissions coach, how Mel decided to trust him with his daughter's dream to get into UC Berkeley. Mel trusted Pat so much that he donated $140,000 to Pat's charity. He wanted to help other kids get into college as well. You will hear how Mel believed Pat Matthew kept his word and worked with Jenna on her test and applications. You'll see that Jenna applied and got into several colleges, including her dream school of UC Berkeley. Mel couldn't have been happier that Jenna's hard work had paid off. But that happiness that Mel felt has ended, because it turns out that Jenna's admissions coach, Pat Matthew, is a professional cheater. He cheats in order to maintain his reputation as the best. He concocted lies on Jenna's college applications, the same lies that he told on so many other applications. Pat faked an athletic profile and a recommendation letter. Pat lied to Mel, saying that Mel's charitable donation would be used to help underprivileged kids, when really, that money was used to cover up Pat's sophisticated cheating operation. Now, Pat wants Mel to pay for those lies. Pat and the prosecution want you to believe that Mel is a terrible father. A father who doesn't think that his daughter is smart. A father who doesn't believe in his daughter's abilities. But that is not Mel Smith. The truth is that our client is nothing more than Pat's scapegoat. Mel was duped into hiring a talented con man to help his daughter get into college. Pat convinced the Smiths that he could help Jenna improve her test scores. Pat fooled them into believing that he was a talented admissions coach, the best in the business. He convinced them that he was such a good person that he even helped kids who couldn't afford his services. The Smiths were so convinced that without hesitation, they made a donation to Pat's charity at his suggestion. They donated because that's who the Smiths are. They're a family who regularly give to charity. You can say, perhaps, that Mel was gullible, that he should have been more careful, that he shouldn't have been so quick to trust Pat Matthew. But that doesn't make Mel guilty of fraud. The prosecution will point out that Jenna's test scores improved a lot. Yes, her scores did improve, but that improvement made total sense to Mel for many reasons. Jenna studied a lot, she worked hard with the tutor, and Pat had Jenna assessed for a learning disability. She got double time on the test that she took in order to accommodate that disability, and she took a different test than the PSAT. This test focused on her strengths, reading and writing. Even if, as Pat suggests, the test scores were changed and the ADHD diagnosis was fake, Mel never knew any of that. Mel didn't know that the doctor Pat recommended was possibly fraudulent. Mel didn't know that Pat bribed the golf coach. In fact, you won't see any evidence that shows Mel knew about any of these crimes. If the prosecution had that evidence, they would show you, but they can't, because that evidence doesn't exist. Neither the emails between Pat and Mel, nor the phone call recorded by police show that Mel knew about the fraud. Any crimes were the work of Pat and Pat alone. Pat added the false information on Jenna's resume. Pat got a golf coach to write a fake recommendation letter. Pat connected Jenna with the supposedly crooked psychiatrist. These actions were taken without the Smiths' knowledge or their approval. Not only was this a complete breach of trust, it was hurtful because of what it says about Mel as a parent, that he doesn't believe in Jenna or her abilities. Nothing could be further from the truth. At the end of this trial, my co-counsel Nabila will ask you for a verdict. The only verdict that you can give is not guilty. Remember, there is a cheater in this case, but that cheater is Pat Matthew. Thank you.
Thank you, counsel. Are you ready to call your first witness, prosecution?
Yes, Your Honor, the prosecution would like to call Pat Matthew to the stand.
Okay. Mr. Matthew, you've been sworn in, and you may proceed with your examination.
Thank you, Your Honor. Please state your name for the court.
Yes, my name is Pat Matthew. That's Matthew without an S.
What did you do for a living?
So I'm currently unemployed, but I used to run an admissions consulting business.
Why are you testifying here today?
Last year, I got caught using some illegal methods in my admissions consulting business. I was charged with more than 220 counts, honest services wire fraud, that type of thing. And I cut a deal with the government. They would reduce my possible sentence in return for me helping them with the investigation and prosecution of my clients.
You mentioned that you cut a deal. Would you recognize a copy of this deal if it were presented to you?
I would, yeah.
Showing the court and opposing counsel what has been marked as Exhibit 2.
You may proceed.
Showing the witness Exhibit 2. All right, seems we're having some technical issues. I'm just going to hold up Exhibit 2 here. Mr. Matthew, could you identify this document for the court?
This looks like a copy of the cooperation agreement that I entered with the government.
How do you know this?
It says cooperation agreement between me and the United States up top, and it has my signature on the bottom.
At this time, we move to have Exhibit 2 admitted to evidence. The authenticity of this document has been stipulated.
Exhibit 2 will be admitted at this time.
Mr. Matthew, were there any conditions on this agreement?
Yeah, so this agreement requires that I cooperate with the government and I testify truthfully to my experiences with my clients and with any investigation that we do. If I don't and the truthfulness of that testimony is going to be determined by the U.S. Attorney's Office, so it's going to be verified.
What happens if you don't do that?
If I don't testify truthfully, then this agreement will be completely voided.
What happens if the agreement is voided?
Apparently, upon conviction, I could be facing more than 800 years in prison and a fine more than $300 million. And while my admissions consulting business did well, it didn't do that well.
What happens if you do cooperate?
So my cooperation, if I cooperate with the investigations and with testifying, the government was going to recommend a sentence of 15 years.
Does the agreement lessen your sentence if the defendants you testify against are convicted?
No, there's nothing in the agreement that says anything about having a lower sentence if the people I testify against are convicted.
I'd like to tell the jury more about this case. Did you ever provide your services to Mel Smith?
Yes, yeah, Mel Smith was one of my clients.
How did you and Mr. Smith first get into contact?
Mel emailed me the end of the year in, I think, about 2015. He reached out to ask about contracting my services for his daughter, Jenna.
Would you recognize a copy of this email exchange if it were presented to you?
I would, yeah.
Showing the court and opposing counsel what has been marked as Exhibit 3. Showing the witness Exhibit 3. Mr. Matthew, could you please describe this document for the court?
Yeah, it looks like a copy of my email exchange with Mel Smith when he first reached out to me.
How do you know this?
It's my email in the to's line, and this is the communication I had when we set up our first meeting.
At this time, we move to have Exhibit 3 admitted to evidence. The authenticity of this exhibit has also been stipulated.
Exhibit 3 will be admitted at this time.
Mr. Matthew, what was discussed in this email exchange?
So initially, Mel reached out to me about his daughter, Jenna, applying to colleges in 2016. Told me I was the person to see about this, which he was right about that, and asked to meet up.
Did you discuss any other logistics?
Yeah, so we did set a time to meet. I suggested right after the new year on January 2nd. And I did give Mel a warning ahead of time. I told him that we're the best in the business. And so depending on how much work it would take us to get Jenna's file where it needed to be, we could be charging up to 6 figures for our services.
How did Mr. Smith react to the price of 6 figures?
Mel just said that price isn't a concern and that he wants what's best for his daughter.
Where did you first meet Mr. Smith?
We set our first meeting to be in Mel's house in Newport Beach.
And when did this meeting occur?
January 2nd, right before lunch at 11.
Who was present for this meeting?
Mel was there for the entire time. His husband, Andy, was there for a little bit at the beginning, but Andy ended up having to leave. So I mainly met with and worked with Mel for this process.
What happened during this meeting?
So first I talked about kind of the price after looking at Jenna's preliminary facts in her file. The number I ended up quoting to Mel was about 150 grand for getting Jenna into the schools that she wanted.
How did Mr. Smith respond to that price?
Mel just asked me if I would be willing to take a check and pulled out his checkbook then and there.
Did Mr. Smith then write you a check for that price?
He wrote me 2.
Lead-in question, Your Honor.
I'm sorry, what's the objection?
Leading question, Your Honor.
I'll sustain the objection. Rephrase, counsel.
Of course.
Move to strike.
Granted.
What happened after you quoted that number for Mr. Smith?
Mel wrote me 2 checks totaling to $150,000.
Why 2 checks?
I realized pretty early on in running my admissions consulting business that that 6-figure digits running into the account of admissions consulting could look pretty suspicious. So I actually started a not-for-profit on the side. And for a lot of my wealthier clients or clients that I had to charge upwards of 6 figures to, I would suggest that they write a smaller check amount. In Mel's case, it was about $10,000 for the actual admissions consulting business. And then a much larger check account. In Mel's case, was the remaining $140,000 balance. And that would be written to the not-profit.
I'd like to learn more about your plan for Jenna. What did you talk about after you talked about price?
So we dove into the plan. I described to Mel a 2-pronged plan to get Jenna up to where we would need to be to get her into the schools that she wanted. We talked about we talked about adjusting her test scores, and we also talked about building a student athletic profile.
How involved are the students and parents in this process usually?
Generally, students have no idea what's going on. We try to keep it hidden from them as much as we can. Parents, I am completely transparent with. It's hard to charge 6 figures for a service if parents don't know if they're getting the value that they're paying for. So I'm upfront about the fact that we are going to get results and that they are going to get into the schools that they want with the techniques that we use.
How did you carry out this plan for Jenna?
So the first prong was the one we tackled first, which was increasing her test score. I had taken a look at her PSAT test score. It was only at a 1080, so I knew we had to boost that. So my first step was to get her to switch from registering for the SAT, which is an acronym of 3 letters, to the SAT.
And what are the SAT and the SAT?
They're both standardized tests that colleges will accept as a sign of aptitude for potential applicants.
Why did you have Jenna swap tests?
Well, the main reason that I had her swap tests was because I actually own a testing center for the SAT. And it's one where I have associates in there that can inflate the score. As a secondary reason, I was worried that if the score jump from the PSAT to the SAT was too high, it might draw some suspicion. And so I figured that it would be smartest to get her into that other testing center and into that other test so that the jump would look less suspicious.
So you said that Jenna took the test at your center. Did your associate end up changing her scores?
Yeah,
Your Honor, leading question.
May I respond?
No, I believe I'll overrule that. I think that's permissible. You may proceed. You may answer the question.
My associate did end up changing her scores after she turned in the exam.
What would Jenna's original score have been?
She would have originally gotten a 1090, so not that much better than she had scored on the PSAT.
And what did your associate change her score to?
He boosted it up to about a 1480.
How did you make sure that Jenna would be taking the test at your center?
So I have an associate who's a psychiatrist, and I had my associate diagnose her with a learning disability so that she would require accommodations, and those accommodations would get her put into my testing center.
How did that learning disability end up getting Jenna moved?
So I had my associate prepare a letter, and then I had Mel submit that letter to College Bound, the administrators of the SAT, so that they could get her moved into my testing center.
Would you recognize a copy of this letter if it were presented to you today?
I would, yes.
Showing the court and opposing counsel what has been marked as Exhibit 7. Showing the witness Exhibit 7. Mr. Matthew, could you please identify this document for the court?
This looks like a copy of the letter that I had Dr. Gebo, my associate, prepare to diagnose Jenna.
And how do you know this?
It looks just like the copy that I had Mel submit.
At this time, we move to have Exhibit 7 admitted to evidence. The authenticity of this document has been stipulated.
7 will be admitted at this time.
Mr. Matthew, how does this letter say that Dr. Gebo diagnosed Jenna?
Dr. Gebo wrote that she performed a battery of tests to get her facts together, and that she used written exams and observation on the battery of tests that she performed to get to her diagnosis.
To your knowledge, did Dr. Gebo and Jenna ever meet in person?
I don't know of them ever having met in person, no.
Where was Dr. Gebo working?
Dr. Gebo was working out of Atlanta, Georgia.
Did the letter that Mr. Smith received reflect this in any way?
Yeah, it has Dr. Gebo's address right up in the letterhead.
Did Mr. Smith ever ask you any questions about Dr. Gebo?
No, Mel never questioned anything about Dr. Gebo.
I'd like to move back to discussing the SAT some more. Did you ever tutor Jenna?
No, I never provided tutoring for the SAT or for any standardized exam. I mainly worked with her on her resume.
You mentioned that Jenna would have gotten a 1090 on the SAT. Would that score have been good enough to get her into her choice schools?
Objection, speculative.
Sustain.
May I respond, Your Honor?
You may.
Mr. Matthew has worked in the field of standardized test preparation and college admissions for over 15 years. It is his job to identify how well students need to do in order to get into certain schools. I argue that this is not speculative because this is information that Mr. Matthew needs to know for his daily line of work.
I'll let you proceed with questioning to lay the foundation you just explained.
Thank you, Your Honor. So Mr. Matthew, would a 1090 have gotten Jenna into her dream schools?
Lay the foundation before you answer that, counsel.
Of course. Mr. Matthew, what is your experience with having students admitted into colleges based on their test scores and other accomplishments?
I mean, we have a lot of knowledge based just on the fact that we have a really great success rate with getting a lot of students into the schools of their dreams. And so I've had a lot of work trying to figure out what score ranges are just high enough that they would allow somebody to get into a school without being so high that it's suspicious for that person, and trying to work through which schools are more likely to be suspicious of inflated test scores, which schools are more likely to be less suspicious, things along those lines.
Okay, you may proceed. The objection goes to the weight of the answers rather than its admissibility. You may ask the question now, counsel.
Thank you. So, Mr. Matthew, would a 1090 have gotten Jenna into her dream schools?
I mean, I highly doubt it. Jenna was looking at some really top tier schools. She was looking at Berkeley. She was looking at Stanford. I think, you know, even with a fake athletic profile, a 1090 would have been a stretch.
So what did you do after raising Jenna's SAT score?
That's when we turned to the second prong, which was looking at constructing a fake athletic profile.
How did you turn Jenna into a student athlete?
So the main part of that plan was actually getting in contact with another associate of mine, a golf coach at the University of Scenic, California, in LA, Hampton Zeta. I would reach out to Hampton, and I would usually pay Hampton a pretty hefty sum. In this case, it was about $30,000. And in return, Hampton would sign off on a recommendation letter I wrote and make a call to the USC admissions office, recommending Jenna based on her golf accomplishments.
Was any of that somehow included in Jenna's application?
Yeah, when I worked with Jenna on her resume, we made sure that right at the top with her rest of her accomplishments, we put in a section about her golfing accomplishments, and what kind of things that she had there for golfing.
I'd like to tell the jury about what happened after the scandal went public. What happened after your arrest?
So after I got arrested, I turned over, like the FBI got their hands on all my records, and I ended up turning over a list of my clients as a part of the work that I was going to start doing with the FBI.
Did you do anything else for the FBI after your arrest?
Yeah, so they were interested in a couple of my clients, including Mel Smith, and they wanted me to get on the phone with Mel while wearing a wire so they could try and investigate him.
Would you recognize a transcript of this call if it were presented to you?
I would, yes.
Showing the court and opposing counsel what has been marked as Exhibit 12. Showing the witness Exhibit 12. Mr. Matthew, could you please identify this document for the court?
It looks like a copy of the transcript of the conversation between Mel and me when I was wearing a wire.
How do you know this?
It's got my words and Mel's lines written down there, and it has the date of our conversation, which was March 13th of last year.
At this time, we move to have Exhibit 12 admitted to evidence. The authenticity of this document has also been stipulated.
12 will be admitted at this time.
Mr. Matthew, what did you discuss in this phone call?
So I started off with all the usual niceties, and then I brought up the news from the day before to Mel.
How did Mr. Smith respond?
Mel said that it's all he and Andy had been talking about after they saw it.
What did you say next?
I brought up that more than 50 people were indicted in what I was talking about with the news.
And how did Mr. Smith respond?
Mel told me that he was relieved that my name wasn't on the list.
What list was he referring to?
I mean, we were talking about the news of the college admission scandal. So Mel was referring to the list of people who had been indicted in the college admission scandal.
How did you feel when Mr. Smith suggested that your name could have been on this list?
I mean, I guess I wasn't too surprised since I had been completely transparent with Mel and I had told him everything that we were doing. So I guess that because of how much I had told him, he might have been worried that I would be on it.
What did you say after that?
So I told him that I'm calling exactly about the fact that my name wasn't on the list, and I told him that if he were approached by the FBI to just tell them that he had hired me for admissions counseling.
How did Mr. Smith respond?
He told me that he understood.
What did you mean when you said that?
I meant to not tell the FBI about changing the test scores or bribing the coach or any of the other things that we had done.
What happened next in the call?
So after Mel told me that he understood, I asked Mel how much Jenna knows.
Did Mr. Smith ask what you were referring to?
No, he just told me not to worry about Jenna.
And then what happened?
At the direction of the FBI, I tried to goad Mel into telling me a little bit more. I asked him if he had told Jenna that we changed her scores. And that's when Mel stepped away from the phone, and for about half a minute, there was just some muttering. I couldn't really tell what was going on. And then when Mel came back, his tone had shifted completely. He said that he had no idea what all of this was about and that I shouldn't call him again.
Thank you for your time, Mr. Smith. Mr. Matthew, goodness.
Thank you, Mr. Matthew. Okay, does the prosecution rest at this time?
Yes, Your Honor.
Okay, thank you, counsel. Defense, do you have a witness to call?
Your Honor, we would like to cross the witness.
Thank you for the correction, counsel. Yes, you may cross.
Thank you, Your Honor. Mr. Matthew, let's go over your arrest and the plea deal that you have with the government. You were arrested recently for fabricating college applications, correct?
Yeah, I was.
Also for bribing individuals associated with college admissions.
Yeah, that was part of what I did.
I'd like to approach the witness with Exhibit 2, which has already been admitted into evidence, Your Honor.
You may do so.
Mr. Matthew, the FBI charged you with wire fraud.
Yes.
You were also charged with honest services fraud.
Yeah, honest services wire fraud.
You were charged with conspiracy.
Yeah, conspiracy to commit the frauds, yes.
In all, you were charged with 220 separate counts of these crimes.
Yes.
If convicted, you face up to 800 years in prison.
Yeah.
In line 3 of your plea agreement, you admitted that if you were tried, you would be convicted of all 220 counts, correct?
Yes.
I'm sure you were nervous when you learned that you could face 800 years in prison.
I mean, yeah.
These crimes also carry a fine of up to $300 million. Is that right?
Yeah.
You agreed to plead guilty?
I did agree to plead guilty to one of the counts.
So you cut a deal with the government in exchange for your testimony?
Well, I cut a deal in exchange for my help, yeah.
You cut a deal in exchange for testimony?
Testimony was part of the help, yeah, but I agreed to cooperate with the prosecution of a couple of their defendants.
Is that a yes to my question?
Yeah.
As part of your deal, you agreed to cooperate with law enforcement by speaking about the parents who hired you.
Yeah, that was it.
And instead of 800 years, you'll serve 15.
Yep.
9 years with good behavior.
Yeah, I hope so.
In line 5 of your plea agreement, you agreed to cooperate in the prosecution of Mel Smith by giving testimony.
Yes, that's one of the defendants mentioned.
In return for this testimony, you will serve 15 years instead of 800.
Yeah, in return for my cooperation by providing testimony and other documents.
Your Honor, I'm handing what's been marked as Exhibit 1 to the court and to opposing counsel, permission to approach the witness.
You may do so.
Mr. Matthew, could you tell me what this document is?
This is the declaration I prepared.
Does this look like a fair and accurate representation?
Yeah, it seems like it.
Your Honor, at this time, I'd like to move Exhibit 1 into evidence.
Exhibit 1 will be admitted at this time.
Now, I'd like to move on to the businesses that you ran. In your declaration, you said your company made $30 million from your admissions consulting business.
Yes.
You've been operating your admissions consulting business for 15 years, yes?
Yeah, about 15 years.
You have helped approximately 150 high school students get into colleges dishonestly.
I mean, I've helped about 150 high school students get into college, yeah. We did have some legitimate services that we offered.
150 approximately of those students you helped dishonestly, isn't that right?
Yeah.
When you said dishonestly, you meant by fabricating documents.
Yeah, sometimes.
You also inflated test scores.
Yeah.
You even photoshopped faces of students onto the bodies of athletes.
On occasion, if that's what was warranted.
You fabricated the college application of the very first student you helped, isn't that right?
Yeah, I did have to stretch a little bit there. There was a little exaggeration or a half-truth here and there.
You testified in your declaration that of those students, law enforcement seemed most interested in your famous clients.
Yeah, it seemed like they were definitely really interested in the famous clients.
Of those clients, you also testified in your declaration that Mel Smith was your most famous client.
Yeah, definitely. Mel Smith is a big name actor.
You run 2 organizations, correct?
Yes.
Reach for the Stars is an admissions consulting business.
Yeah, that's the name that I officially incorporated my consulting business under.
You do genuine lawful consulting work in part with Reach for the Stars.
Yeah, we have tutors who help students prepare for tests or who help write college essays, strategists who help navigate admissions processes, things like that.
You also use Reach for the Stars to fabricate college applications.
Yeah, that is something else that Reach of the Stars does, or did.
Your other organization is Front of the Classroom.
Yeah, that's the nonprofit that I run or ran.
Front of the Classroom is a nonprofit that purports to help underprivileged kids obtain a college education.
That is what we incorporated for, yeah.
Your nonprofit does not actually help any underprivileged kids.
No, we used it mainly as a shell corporation.
This was to hide the extravagant costs of using fraudulent means to help rich kids get into top universities.
Yeah. Like I said, you didn't want to raise too many eyebrows.
Finally, let's move to Mel's involvement in your illegal acts. You were the one who bribed the golf coach at University of Scenic, California to write a letter about Jenna.
Yeah, I did. I bribed Hampton to sign off on the letter I prepared.
You paid Hampton the $30,000.
Yes.
You testified earlier that you keep the kids out of the process as much as possible.
As much as we can, yeah. We don't want the kids to know.
You added golf statistics to Jenna's resume.
Yeah, I made sure that we had it up there for her. Reach for the Stars, as an admissions consulting, the royal we.
Okay. You testified previously that Jenna was present.
Objection. Assumes facts not in evidence.
During the direct, Your Honor, the witness stated that him and Jenna went over the resume and added the golf statistics.
Is that a correct statement of your previous testimony, sir?
I did help Jenna with her resume, yeah. But I don't know if I would be correct to characterize it that way.
How would you characterize it?
That I did help Jenna with her resume and that I made sure that Jenna's resume included a portion about the golf section.
Okay, you may proceed, counsel.
You connected Jenna with the psychiatrist, Dr. Gebo.
I did, yes.
You received Jenna's disability letter from Dr. Gebo.
I did, yes.
You gave Mel the disability letter.
I did, so that Mel could send it on to College Bound.
You told him to submit the SAT to the SAT testing company, College Bound.
Yes.
You testified that you had a colleague change Jenna's SAT answers.
Yes, that is part of what we did.
Mel did not change those answers.
No, Mel didn't change them.
You knew falsifying college applications was wrong.
Objection. Relevance.
Goes to credibility, Your Honor.
Overruled. I'll allow it. You may answer the question.
Would you like me to repeat the question, Mr. Matthew?
Yes, please.
You knew falsifying college applications was wrong.
I mean, yeah, I guess I'm going to be serving jail time for it now.
That's a yes?
Yeah.
You know bribing college athletic coaches is also illegal.
Yeah.
And you know that it's cheating to change Jenna's test answers.
Yeah.
You also knew that it was illegal to set up a shell company as a way to funnel money.
More prejudicial than probative, Your Honor.
No, I'll allow it, counsel. Overruled.
To repeat, Mr. Matthew, you knew it was illegal to set up a shell company as a way to funnel money.
I mean, yeah, I guess.
Yes?
Yeah.
Thank you. That's all.
Your Honor, permission to redirect?
You may.
Mr. Matthew, just a couple more questions. Did you benefit in any way from would you benefit in any way from Mel being found guilty?
No, not that I know of. There's no additional benefit from Mel being found guilty that I would get from this.
Would you benefit in any way from helping achieve a guilty verdict for Mel?
No, I did my job and I cooperated with the FBI and the government completely.
Did you inform Mel of your plan and all of its illegal components?
Yep, I'm always transparent with the parents that we work with.
Thank you, Mr. Matthew. The prosecution rests.
Okay, thank you, counsel. Defense ready to proceed?
Your Honor, may we request a brief recess at this time?
Okay, how long are you thinking of, counsel?
Just 5 minutes.
Okay, court is adjourned and recessed for 5 minutes.
Thank you.
Okay, is everybody back? Are we ready to proceed?
The defense is ready to proceed, Your Honor.
Okay, you may proceed when you're ready, counsel. Call your first witness.
The defense calls Mel Smith.
Okay.
Would you please state your name for the court?
I am Mel Smith.
What do you do for a living?
I am a Hollywood actor.
What is the name of your spouse?
His name is Andy Smith.
What does he do for a living?
He's a venture capitalist.
How many children do you have?
We have 2 beautiful children named Cher and Jenna, both equally talented and hardworking.
What do your daughters do?
My daughters are both college students. Cher is a senior at NYU and Jenna is a sophomore at University of California, Berkeley.
When did you first hire an admissions coach?
My husband and I first hired an admissions coach for our eldest daughter, Cher, when she was going through the admissions process.
Tell us more about that.
Sure, well, Cher came to us and asked for an admissions coach because Andy and I don't really have experience in the college admissions process, so we hired one to help her out, and together with her hard work and the admissions coach's advice, we got her into a really great school.
What improper acts did you ask Cher's coach to take?
None.
Let's talk about Jenna now. How did Jenna get into college?
For our daughter, Jenna, we wanted to pursue a very similar route as we did for Cher, and she actually came to us and asked for an admissions coach, so we decided to hire one.
What improper acts did you ask Jenna's coach to take?
Absolutely none.
What company did you hire for Jenna?
We hired Reach for the Stars, Mr. Matthews' company.
Why did you hire Reach for the Stars?
Well, Andy heard about Mr. Matthew through a close buddy of his at the office, and via word of mouth, we decided to reach out because we heard he was the best in the business.
What kind of recommendation did you receive?
It was an extremely passionate one from one of Andy's closest coworkers, so we had no reason to doubt its veracity.
How did you first contact Mr. Matthew?
I sent him an email. Actually, I sent him an email right after Andy gave me the recommendation because I know the waiting lines for the best admissions consultants can be quite long.
I'd like you to take a look at the emails, Exhibit 3, which is already submitted into evidence. These are up on the screen for you.
Sure.
Let's look at the first email to Mr. Matthew at the bottom. What did you say in this email?
I let him know that our daughter Jenna was applying to college and we hear that he's the best in the business and I wanted to meet him.
Let's look at the second email. What was Mr. Matthew's response?
He emphatically expressed that he could help us and suggested a date that we both meet. And of course, he mentioned that his price tag is quite hefty, up to the 6-figure range, actually, is what he said.
Let's look at the third email. What was your reply?
Well, I replied to him that we want the best for our daughter, and price is not a concern, and it's honestly never a concern when it comes to my kids. And I confirmed the January 2nd meeting date.
How many total emails were sent?
3.
What improper acts are discussed in these emails?
None.
Let's go back to the first email at the bottom. What's the date and time for this email?
It looks like I sent this email on December 28th, 2015 at 4:30 p.m.
I'd like you to take a look at the date and time on Mr. Matthews' email, the second email. How much time did it take for him to respond?
It looks like he responded in just 8 minutes to my email.
Let's look at the third email. How long did it take for you to follow up?
I responded almost just as fast in under 10 minutes.
Sorry, what was that?
It looks like it was under 10 minutes.
On what date did you and Mr. Matthew agree to meet?
We agreed to meet on January 2nd.
How many days after these emails was that?
It looks like it was 5 days. Yeah, it was the holidays also, so we were crazy busy hanging up decorations with the kids and celebrating, so we wanted to meet after the new year. So 5 days.
I'd like to talk about that January 2nd meeting now with you. Walk us through what happened.
Well, Mr. Matthew came over to our house and met with me and Andy, and we talked about Jenna's needs. We began by discussing her lackluster PSAT score and how we needed to improve that somehow via some of his services. And he recommended connecting her with a doctor he knew, just because he saw how disappointed I was in her score, and he suggested that she might have a learning disability, which would explain my disappointment in the 1080 that she got.
When did you decide to hire Mr. Matthew?
We pretty much decided on the spot on that very day. And
What improper, go ahead.
I'm sorry, I just mean we decided in that same meeting to hire him.
What improper acts were discussed to get Jenna into college in that meeting?
None, nothing improper.
How much did you agree to pay for Jenna's counseling?
We agreed to pay Mr. Matthew $10,000 for his consulting services.
How does that compare to what you paid for Cher?
I believe it's almost the same amount. We paid in the $10,000 to $15,000 range for Cher, so this seemed like a pretty fair settlement. I know that might sound like a big number to some people, but it's not for me and Andy. We've been very successful in our careers, so spending $10,000 on admissions consulting is frankly not very much for us.
You said you hired Mr. Matthew at that meeting. Why didn't you take more time to make the decision?
This is one of my biggest regrets. Andy and I were super busy with our personal career aspirations at that time. I was working on a major television show, constantly traveling. We got a great recommendation from Mr. Matthew and didn't feel the need to put in the proper due diligence when it came to hiring him. So we relied on this in-person meeting primarily, in which he seemed super competent and passionate about helping us.
In the meeting, what else did you discuss besides Jenna's college admissions plan?
Well, during the time I was there, I believe we also discussed Mr. Matthews' charity. He knows that Andy and I are pretty philanthropic, and I'm sure that's why he brought it up now, but he talked about Front of the Classroom, I believe that's the name, and he gave us a bunch of brochures which talked about the power of every dollar we would donate, where some of the kids end up that solicit this charity services, and there couldn't be anything more than I would want than to help other parents get their kids into just as great of a schools as mine.
How much did Mr. Matthews suggest you donate?
He suggested the exact amount I believe that we did donate, which was $140,000.
Why did you want to donate?
Donating is not out of the realm of normal activity for my spouse and I. We always donate, and if I could help other students who are not as privileged as Cher and Jenna get into schools like that, it would mean the world to me to help out others.
Have you donated to charity before?
Yes, quite a few times. Most recently, I can think of, we donated to charities to help the homeless and to help those afflicted with type 1 diabetes. So it's a pretty diverse pool of charities we've donated to.
Your Honor, I'd like to show Exhibit 6 to the witness. I am presenting this document now to you and the clerk.
You may do so.
Do you recognize this document?
I do.
Can you identify it for the court?
This is the thank you letters or confirmation letter that I received from Mr. Matthews' charity just a couple days after we donated.
Is it a fair and accurate representation of that letter?
It seems like it, yes.
Your Honor, I'd like to move Exhibit 6 into evidence.
Exhibit 6 will be admitted at this time.
How could you have known that the charity was a scam?
Well, I don't think there's any way I could have known, especially after receiving this letter that confirmed that they received my donation. I was super happy that my money would be put to good use.
I'd like to talk now about what happened after you hired Mr. Matthew. After you hired Mr. Matthew, how involved were you with Jenna's applications?
Well, I'm generally a very involved parent. I never miss one of Cher's quiz bowls or Jenna's mock trial competitions. But when it comes to Jenna's college admissions process, I was not as involved as I wanted to be. In fact, I only reviewed her personal statement, and that's because she asked me to. So I can't say that I was as involved as I wanted to be, but I definitely was involved to an extent.
I'd like for you to take a look at Exhibit 7, which has already been submitted into evidence.
Mm-hmm.
This is the doctor's letter. Tell us why you had Jenna assessed for a disability.
Well, I never thought she had a disability until Mr. Matthews seemed to indicate that she might. And he seemed pretty confident in Dr. Gibble's capabilities. So I had her tested because Mr. Matthew told us it'd be the best route to pursue.
Who suggested Dr. Giebel?
Oh, Mr. Matthew did.
What reason did you have to doubt the credibility of this letter?
None whatsoever. She said she performed a battery of tests and came to this conclusion, and honestly, it gave me some closure. It gave me some reason as to why Jenna performed in a lackluster way on her PSAT.
Your Honor, I have a document pre-marked as Exhibit 8. I'd like to show the document to you and opposing counsel.
You may do so.
Thank you. Now approaching the witness. Do you recognize this document?
I do.
Please identify it for the court.
This is a summary report of Jenna's SAT score.
Is it a fair and accurate representation of that report?
I believe so, yes.
Your Honor, I'd like to move Exhibit 8 into evidence.
Exhibit 8 will be admitted at this time.
What is the test date on the score report?
It looks like the test date is October 20th, 2016.
How many months was this after your initial meeting with Mr. Matthew?
I mean, it seems like 10 months. Yeah, 10 months, because we met him on January 2nd. Over 10 months.
Who suggested Jenna take the SAT?
Mr. Matthew did.
Why?
Well, he knew that Jenna was strongest at reading and writing, which is what's tested on the SAT. And he also seemed to think that it would be able to provide her with more accommodations when it came to her newly found learning disability.
How surprising was the change in her test score?
Well, I wasn't surprised at all when I got this report. I'm very confident in Jenna's capabilities. So the fact that I would witness her studying every single night, making her favorite desserts for her as she labored away, coupled with the fact that I know Mr. Matthews' organization provided her with personal tutoring, this score wasn't surprising.
Your Honor, I have a document pre-marked as Exhibit 10. I have provided this document to the clerk and opposing counsel. I am now showing this document to the witness.
May proceed.
Can you identify this document for the court?
This is my daughter Jenna's resume that she submitted in the college admissions process.
Is it a fair and accurate representation of that resume?
Of the one she submitted, yes.
Your Honor, I'd like to move Exhibit 10 into evidence.
Exhibit 10 will be admitted at this time.
What parts of the resume are false?
It looks like only the section on the golf team is false. My daughter never played golf.
What knowledge did you have that this was on the resume?
None.
I'd like for you to now look at the wiretap transcript. This is Exhibit 12, and it's already been submitted into evidence. Tell us how this conversation began.
Well, Mr. Matthew called my home. I picked up the phone, and he immediately brought up the college admissions process that was all over the news. And I let him know that I saw the news and I was aware of it. And I said that I was relieved that his name wasn't on the list.
What did you mean by relieved?
Well, I was being sarcastic, as in like, I was relieved your name wasn't on the list because I know that he did nothing unfair at that time. So I was happy that he wasn't implicated.
How did the rest of the conversation go?
Well, then it took a slightly different turn. After I said that, Mr. Matthew said that the reason why he was calling was because of the college admissions scandal. And I was confused. He then asked me to, if the FBI were to call me, I should let them know that I hired him for admissions consulting. And I said, I understand, because that's what I hired him to do. And then he asked me if my daughter Jenna knew anything. And I told him not to worry about her because he wasn't affected at all by the admission scandal at large that was going on. And I wasn't confused that he was asking about her because he was like a father figure to her at this point. But then he said, did you tell Jenna that we changed her scores? And at that point, I put the phone down, asked my husband, Andy, if he knew at all what Mr. Matthew was going on about. He didn't. He told me that I should just get off as quickly as possible. So I asked Mr. Matthew to never call us again, and I hung up the phone.
Throughout Jenna's college admissions process, what knowledge did you have of the crimes that Pat was committing?
None.
When did you ask him to take such actions?
Never.
Why are you here?
I'm here to clear my name and tell the truth. Andy and I got married a few years ago, over a decade ago, actually, and we had a lot of trouble having kids, even in the state of California. And once we did, they became the brightest lights in our lives, and I could never imagine doing anything to put them in harm's way. So I'm here today to clear my name, clear my daughter's name, and just let us get back to a normal life.
I have no further questions, Your Honor.
Thank you, counsel. Cross-examination.
Yes, Your Honor, thank you. Good evening, Mr. Smith.
Good evening.
First, I'd like to clear up a few things. So earlier in your testimony, you said that you were, quote, not as involved as you wish you could have been with your daughter's college applications. Is that correct?
Yes.
Okay, so your testimony today is you weren't very involved.
Not as involved as I wanted to be. So yes, I would say I was not very involved.
Okay, I would like to show the court and opposing counsel the exhibit marked Exhibit 13. It is a transcript of a conversation between Mr. Smith and the hosts of Stand Up and Face the World.
You may do so.
I'm going to now hand the transcript to Mr. Smith. Mr. Smith, could you take a look at page 21, lines 13 and 14? You can read them to yourself as I read them aloud. Quote, I was very involved in their college applications too. Did I read that correctly?
You did. Very is a relative term, very relative to other parents, not very relative to the standard that I hold myself to.
Okay, but at the time of the interview, you considered yourself very involved in their college applications.
Relative to my friends and their children, yes.
So that's a yes. All right. I would also like to move to admit Exhibit 13 into evidence. The authenticity of exhibit has already been stipulated to.
No objection, it will be admitted at this time.
No objection, Your Honor.
Thank you, Your Honor. So now, Mr. Smith, I would like to turn to another part of the transcript. Now, you said that you hired an admissions consultant for your older daughter's share, correct?
Yes,
And you paid between $10,000 and $15,000 for that admissions consulting.
I did.
So you knew what a, to use your own words, legitimate admissions consulting firm would cost.
I did.
Okay. Now, Mr. Matthew wrote to you in an email and said that his services could cost you 6 figures.
He did say that.
And you responded that price was not a concern.
I did. People always ballpark really high with me.
Mm-hmm. Okay, so now I would like to move on to your meeting with Mr. Smith, or Mr. Matthew, sorry. You met with him on January 2nd of 2016?
I did.
Okay, and it was there that you discussed how he would help get Jenna into college.
Yes.
At the end of that meeting, you wrote 2 checks, is that correct?
Yes, I wrote one for the charity and one for the consulting business.
Would you recognize copies of these checks if they were presented to you today?
I should.
Okay, I would like to show the court and opposing counsel the exhibit marked as Exhibit 4. I would also like to hand that to the witness. And Mr. Smith, do you recognize this exhibit?
I do.
And what have I handed you?
This is a check I wrote for Mr. Matthews's admissions consulting business, Reach for the Stars, for $10,000.
Okay. At this time, I'd like to move to admit Exhibit 4 into evidence.
4 will be admitted at this time.
Thank you, Your Honor. So that was the first check that you wrote, correct?
Yes,
But then Mr. Matthew asked you to write a second check.
he did.
And would you recognize a copy of this check that was presented to you?
Yes.
I would like to direct the court and opposing counsel to the exhibit marked Exhibit 5. I will hand that to the witness as well. And Mr. Smith, what have I just handed you?
This is a check I wrote to Mr. Matthew per his recommendation for $140,000 to his charity to help underprivileged children.
And does this look like a true and correct copy of that check?
It does.
I'd like to now move to have Exhibit 5 admitted into evidence.
5 will be admitted at this time.
Thank you, Your Honor. Now, as you just said, that check was for $140,000, is that right?
Yes.
Objection asked and answered.
Sustained, but let's move on.
And that check was addressed to the nonprofit owned by Pat Matthew.
Yes.
Okay. So now I would like to move on to Jenna's test scores. Or actually, sorry, just coming back to the charity for just a moment. You stated earlier that you had previously donated to charities for diabetes and homeless populations.
I have.
And you had never before donated to a charity for underprivileged students.
Not directly. They could be included in the homeless population, I suppose. I'm not discriminating against what charities I donate to, but.
But in short, you hadn't donated to this type of charity before.
Not that I know of, off the top of my head.
So no.
I don't know. I've donated to many charities.
Okay, but as far as you know, you hadn't donated to a charity specifically for underprivileged students before.
Objection asked and answered, Your Honor.
No, overruled. You may answer the question, counsel. Is that a yes or no? Can you answer it yes or no?
I cannot answer it yes or no, because I don't know for sure.
Okay.
So now I would like to move on to Jenna's test scores. She scored a 1080 on her PSAT.
Correct.
And did you think that was going to be a good enough score to get her into Berkeley?
Well, I myself wouldn't know, but judging by Jenna's reaction, she was so disappointed in herself. So no, I didn't.
So Mr. Matthews suggested a psychiatrist to potentially diagnose Jenna with ADHD.
He did.
Okay, and Jenna had never been diagnosed with ADHD before.
No.
The psychiatrist did write a letter diagnosing Jenna with ADHD.
Yes,
You saw this letter?
I did.
You mailed it to College Bound, the SAT administrators.
Yes, after Mr. Matthew handed it to me.
And in the letter, which I can present to you right now, it's the exhibit marked Exhibit 7. It has previously been admitted into evidence. Do you see Mr. Smith in this letter where it states that the psychiatrist performed a battery of tests on Jenna?
Yes.
She performed written exams.
Yes.
She also observed Jenna.
Also observed Jenna?
Or performed observation with Jenna.
Yes.
Jenna spoke with the psychiatrist over the phone.
Yes.
She never met with the psychiatrist in person.
I don't know of a meeting that happened in person.
So as far as you know, your 17-year-old daughter didn't go to Georgia to meet with a psychiatrist.
That is correct, as far as I know.
Okay. But you submitted, excuse me. I will move on to the final test score that Jenna received. It was a 1480, is that right?
Yes.
Okay. Now, moving on to the rest of Jenna's college application, I would like to provide you Exhibit 10. It has previously been admitted into evidence, a copy of Jenna's resume. Now, this is the resume that was submitted with all of her applications.
Yes,
And do you see the section where it says golf team?
I do.
Just to be clear, Jenna's never played golf.
She has never played golf.
And she was never on the high school golf team?
Never.
Was she captain of the golf team at any point?
No.
Okay. So finally, after this was all over, Mr. Smith called you on March 13th of 2019.
Mr. Matthew called me, yes.
Mr. Matthew, excuse me. In that call, he began by saying, had you seen the news?
Yes.
You knew that he was referring to the news about the college admission scandal?
He couldn't be talking about anything else. It was on every channel.
Then he said that more than 50 people had been indicted.
Yes.
And by that, you knew that he was referring to the 50 people indicted for the college admissions fraud allegations.
Correct. I couldn't be anything else.
Then you said that you were, quote, relieved that his name hadn't been on the list.
I was. I said it quite sarcastically because I had no doubt in my mind that he was a legitimate, honest guy.
He responded, me too. That didn't give you any pause? Did you think he was also being sarcastic?
I'm sure I did. Yeah.
After that, he asked you if you were approached by the FBI to just say that you had hired him for admissions consulting.
Yes, he did. He did ask me to do that.
You responded, I understand.
Correct, because that's exactly what I hired him to do.
You didn't ask any follow-up questions?
No, I didn't. I was a little bit confused, to be honest, that he would even ask me to do that, but no.
So even though you're confused, you didn't say anything else?
No, not in the moment.
Then he asked you how much Jenna knew.
He did. He cares deeply about Jenna. So that this wasn't an out of the ordinary question for him to ask.
And you responded, don't worry about Jenna.
Right. She didn't seem to be affected by the scandal at all. I know that she knew some people who were, so she was totally fine.
But you didn't ask what Jenna might know?
I'm sorry, can you clarify the question?
Mm-hmm. When Mr. Matthew asked, how much does Jenna know? You didn't ask what that meant?
No, because again, I thought he was talking about the scandal at large and if she knew some details about it and if it affected her.
Okay, moving on. After all of this had taken place, you, or after Jenna was admitted to colleges, you sent Pat Matthew a gift.
I did send him a gift.
This was a Cal Berkeley sweatshirt.
Yes,
It also included $5,000,
it did.
and that $5,000 was in cash.
It was. We wanted to give it in the most accessible way.
And you considered the $5,000 part of a thank you gift of sorts.
For sure, I was so grateful to him. He became such a close friend of ours, a member of the family almost.
All right, nothing further, Your Honor.
Thank you, counsel. Redirect?
Yes, Your Honor. Mel, when Mr. Matthews said you could possibly pay 6 figures in that email, how did you interpret that phrase?
Well, folks always ballpark high with me because they know who I am and they know my financial resources. So I just thought he was another guy like giving me a ridiculous estimate as to his services and I'd be able to water him down after.
Let's talk about the doctor's letter now. What medical expertise do you have in the disability ADHD?
Oh, absolutely none. I've been an actor my entire life and Andy's in finance, so he knows nothing about that.
What about the tests involved in diagnosing ADHD?
No knowledge.
Who put you in touch with that doctor?
Mr. Matthew.
Who asked you to write 2 checks on January 2nd?
Mr. Matthew.
Who asked you to donate $140,000?
Mr. Matthew.
Who said Jenna should take the SAT?
Mr. Matthew did.
Who suggested she get checked for a disability?
Mr. Matthew.
Who did you trust to handle Jenna's college admissions?
Only Mr. Matthew.
No further questions, Your Honor.
Thank you, counsel. Any further witnesses?
No, Your Honor. The defense rests.
Okay. Okay, are we ready to give our closing argument then, counsel?
Yes, Your Honor.
Okay, you may proceed when you're ready.
Members of the jury, money shouldn't buy you everything. But Mr. Smith thought that money could buy his daughter higher standardized test scores, a fake athletic profile, and a learning disability that allowed her extra time and a different testing center. He thought that it could buy Jenna admission to the college of her dreams, a college that she didn't have the merits for. The government must show you 3 things today. First, that Mr. Smith knowingly participated in a scheme to obtain falsified records. Second, that he intentionally participated in this scheme. And third, that this scheme was carried out over wire communication. We must show you these things beyond a reasonable doubt. Members of the jury, this is a high bar to reach, but it is not an unreachable one. It is not that of any possible doubt. Let me give you an example. Let's say you
States the law. May I be heard?
You may.
Your Honor, the reasonable doubt standard is higher than possible doubt.
It is, I'll instruct the jury that that's correct.
Your Honor, I said it was not that of any possible doubt.
Okay, proceed, counsel.
Thank you. Let me give you an example. Let's say you drove to the office one day, parked your car out front, and saw that the odometer read 5,000 miles. After a full day of work, you come back out to find your car parked in the same spot, same mileage on the odometer. A possible doubt would be that perhaps a flatbed truck picked up your car, drove it around town all day, and then dropped it back in the same spot before you noticed. A possible doubt would be that, is that possible? Sure. Is that reasonable? Probably not. Now, let's say there's a scratch on your bumper, maybe from the hook of the pickup truck, or maybe from a car that passed too close in the parking lot. Members of the jury, it is up to you to decide what constitutes a reasonable doubt. Just remember that reasonable doubt is probable. The evidence that you saw today gives no possibility for reasonable doubt as to what Mr. Smith did. First, Mr. Smith participated in a scheme to obtain falsified records. In this case, standardized test scores and college admissions, and he did this knowingly. You heard in the email exchange, Mr. Matthew told Mr. Smith that his services could cost him 6 figures. And Mr. Smith said, price is not a concern, and then paid Mr. Matthew $150,000. Mr. Smith justified this response by saying, price is never a concern when it comes to his daughters. In his
Objection, Your Honor, misstates the evidence.
How so, counsel?
That is not the phrasing that our client has used. He said price, not a concern.
I was referring to what Mr. Smith said in his testimony during the direct examination.
You may proceed. I'll allow that. This is paraphrase.
Thank you, Your Honor. In his interview, Mr. Smith also admitted that this price of $150,000 is unreasonably high for any legal admissions counseling, which he knew because he had paid only $10,000 or $15,000 for that of his older daughter. Members of the jury, love for one's children cannot excuse fraud. Mr. Smith over email also asked Mr. Matthew to keep things confidential, something that would not have been necessary if he believed all of their intentions were genuinely legal. Mr. Smith did not ask for confidentiality in his first email to Mr. Matthew. He only asked for this after Mr. Matthew gave him a price. This shows that Mr. Matthew's concern for privacy does not come from his being a celebrity. It comes from a concern for repercussions for his illegal intentions. Take a moment to look through these exhibits when you deliberate, members of the jury. They show that Mr. Smith knew he was paying for something more than just some tutoring and a clean resume. Mr. Matthew also told you that he told Mr. Smith his entire plan. He told you he had to do this. He couldn't charge 6 figures for something that seemed like run-of-the-mill legal counseling. This means Mr. Smith knew about the fraudulent diagnosis of ADHD. He told you today he received Dr. Gebo's letter, a letter filled with suspicious information. Mr. Smith told you that he did not question how Mr. Smith conducted a battery of written exams and observations over a single phone call. You don't need to be a psychiatric expert to find that suspicious. Mr. Smith also told us he never questioned the need for an out-of-state psychiatrist who could not even meet with Jenna in person. Mr. Smith, a self-proclaimed very involved parent, would have found all of this suspicious if he did not know about the plan. But he did. He paid $150,000 for this plan, and he even helped out by submitting a fraudulent letter to College Bound. Next, Mr. Smith knew that the SAT score was fraudulent, not only because Mr. Matthew told him his plan to do so, but also because he knew Jenna would not have scored nearly as high on her own. Jenna only scored a 1080 on the PSAT. Mr. Matthew told you he never tutored Jenna. He only helped her with her resume. Mr. Smith and Mr. Matthew agree that Jenna mostly studied on her own. Such a drastic score increase, 1080 to 1480, would be extremely unlikely. Mr. Smith would be well aware of this. He told you that he had just experienced the college admissions process with his older daughter, Cher, as he discussed in his interview. And he told you that he was very involved with Jenna throughout her application process. The evidence shows that Mr. Smith knew Mr. Matthew had to change Jenna's score. Mr. Smith also admitted that he knew about the golf section added to Jenna's resume. Mr. Smith—
Objection, Your Honor. Misstates the evidence. Mr. Smith, our client never said that.
Your Honor, I didn't say— sorry. Thank you, Your Honor.
You can clarify in your statement, counsel. I'll allow that.
Mr. Smith admitted today that he read Jenna's college admissions essay and that he was very involved with her throughout the entire application process. That makes it very likely that he at least saw her resume as well. And members of the jury, as you will see when you deliberate, this golf section is hard to miss. Finally, Mr. Smith's responses to the wiretapped phone call clearly show that he knew illegal actions had been conducted. During the phone call, before Mr. Matthew mentioned anything other than the news, Mr. Smith promptly said he was relieved that Mr. Matthew's name was not on the list of those charged with the charges we discussed today. That would be an unusual thing to say if he genuinely believed that all of their conduct had been entirely legitimate. Mr. Smith then responded, "Me too, and that's why I called you." That response seems unusual if Mr. Smith had been being sarcastic. Next, Mr. Smith did not ask why Mr. Matthew felt the need to tell him what he said he already knew, that he had been hired just for admissions counseling. This is because he knew he wasn't. Mr. Smith also didn't ask what Mr. Matthew was referring to when he asked how much Jenna knew. This is because he knew Mr. Matthew was referring to all of the illegal steps from their plan. This evidence shows that Mr. Smith clearly knew about this scheme. He actively participated in it by hiring Mr. Matthew, paying him for his services, and submitting a fraudulent letter to College Bound. Second, not only did Mr. Smith knowingly participate in this plan, he did this intentionally. It was he who reached out to Mr. Matthew to obtain his services. Mr. Smith pursued this, knowing that Mr. Matthew would charge him 6 figures. Mr. Smith knew what he was paying for. Fraud. Mr. Matthew told us that he submitted Dr. Gebel's letter despite its clearly fraudulent qualities. Mr. Smith also knew that his daughter didn't have the test scores or the athletic accomplishments to get into the colleges of her choice. Mr. Smith intended to fix that by paying Mr. Matthew to do whatever it took to make Jenna a qualified candidate. He told us in the email, he said in the email exchange, "We want the best for our daughter. Price is not a concern." These emails and his testimony show that Mr. Smith acted with the intent of getting Jenna into her dream schools at any cost necessary, believing that money could buy him anything. Third, the evidence shows that this scheme was carried out using wire communication. In this case, telephone and internet. As I have said, Mr. Smith requested Mr. Matthews' services via email. Mr. Smith told you Dr. Gebo diagnosed Jenna with ADHD over the phone. Mr. Matthew told you Hampton Zeta called a USC admissions officer to recommend Jenna. The applications were submitted over the internet. Each of these steps was conducted over wire communication. Members of the jury, remember once again that money shouldn't buy you everything. If you believe that Mr. Smith knowingly participated in this scheme to obtain falsified test scores and college admissions, if you believe he intentionally participated in this scheme, and if you believe this scheme was carried out over phone and internet, we ask you to find Mr. Smith guilty of honest services wire fraud. If you can find no reasonable doubt as to these 3 elements, you must find him guilty. So what do you think, members of the jury? Can money buy Mr. Smith a free pass? Thank you.
Thank you, counsel. You may proceed when you're ready, defense counsel.
Thank you, Your Honor. I just need a moment to set up my technology.
Okay, take your time. It's running low. Would you try to discreetly figure a way to plug in the...
Okay, I'll do it.
Okay. You may proceed when you're ready, Counsel.
Thank you, Your Honor. The prosecution is right. Money shouldn't buy you everything. Someone who is here today used money to bribe, to manipulate, to cheat. There is a cheater in this case. That cheater is Pat Matthew. Members of the jury, you have now heard how Pat Matthew ran a sophisticated operation to cheat our college system. Mr. Matthew cheated for 15 years. He cheated how we recognize and reward our children's hard work because he believes money buys you everything. He lied on college applications. He changed test scores. He faked athletic profiles. He bribed. No one denies Pat Matthew is a cheater. At the beginning of this trial, my co-counsel told you that you would hear three things that show our client is not guilty, that show Mel Smith is a scapegoat. 1, Pat's testimony is the only thing connecting Mel to the fraud. 2, Mel has hired an honest admissions counselor before for his daughter's share. No one denies that was legitimate. He had no reason to cheat with Jenna. 3, Mr. Matthew is a professional liar and had a lot to lose if he didn't come here and say Mel knew about the fraud. The prosecution keeps saying Mr. Matthew is only here to tell the truth. But look at the plea agreement he signed. It's up on the screen for you. Look at paragraph 2. Mr. Matthew was charged with 220 counts of crime. So many crimes that he faced 800 years in prison. 800 years in prison. 800 years that Mr. Matthew no longer needs to serve. Mr. Matthew wouldn't be here today if not for this plea agreement. The idea that he doesn't gain anything is ridiculous. If the prosecution tries to tell you one more time, Mr. Matthew only came here to tell the truth, remember this plea deal. This is Mr. Matthew's way of getting out of 800 years in prison. This is the person that the prosecution wants you to trust. The prosecution wants you to believe everything Mr. Matthew says because their whole case rests on him. But you've now heard Mr. Matthew right here. You heard him explain how he ran this elaborate scheme, how he made up stuff for 15 years. He was so good at making stuff up, he could edit a photo of someone and make you believe that person was a star athlete. Is it really believable that someone as calculating as Mr. Matthew couldn't make some more stuff up to escape 800 years in prison? He's done exactly that with our client, Mel Smith. Mel is simply a scapegoat. Let's talk about what the prosecution needs to prove today. The government has to prove that Mel knew about the cheating because it's one of the elements of the crime. What are elements of a crime? Think of the elements like the walls of a house. To have a house, you need 4 walls. If one of those walls is missing, the building collapses. In the same way, to have a crime, you need all of the elements. If one of those elements is missing, you don't have a crime. let's look at the elements. I'd like for you to look at the jury verdicts form you'll have with you in your deliberations. It's up on the screen for you. Let's just focus on one element. Number one. In fact, let's just focus on one word, knowingly. Did the defendant knowingly devise or participate in a scheme to defraud? Knowingly is the most important word in this sentence. It's the word you should focus on in your deliberations. It means the government must have shown you that Mel knew about the fraud. None of the evidence shows that. We don't contest that Jenna's golf skills on her resume were false, that her test scores and disability might be fake. What we contest is that Mel did not know someone was playing with his daughter's future this way. The prosecution has given you nothing that shows Mel knew about the cheating, because they can't. That evidence doesn't exist because Mel didn't know Mr. Matthew was committing fraud. That alone should lead you to acquit Mel. The government also needs to prove the elements beyond a reasonable doubt. I'm going to explain to you what the standard is, because unfortunately the prosecution did not do a good job of representing what a high standard of proof this is in the law. What does reasonable doubt look like? Imagine that I have a box and I put a cat and a mouse in that box and close it for 1 hour. I open it up an hour later, there's only a cat in there, no mouse. I can guess that the cat ate the mouse, but over here in a corner, there's a tiny hole, large enough for a mouse to squeeze through. That hole is reasonable doubt. There are 3 holes in the prosecution's argument. The 3 points that my co-counsel Christina and I have been making to you. 1, nothing the prosecution has shown you outside of Mr. Matthews' testimony shows Mel knew or did anything wrong. Look at the emails. They're up on the screen for you. Is there anything in there about fraud, about bribery, about faking a disability? There's nothing in there. Let's look at the wiretap. There's nothing in there that says Mel knew about changing Jenna's scores. There's nothing in there that says Mel knew about bribing a golf coach. There's nothing in there that says Mel knew the charity was a sham. There's nothing in there. 2, all of Mel's actions here are the same honest actions he's taken in the past. He hired an honest admissions coach before for share. Mel has made honest donations to charities before, multiple times. Those are the actions of a loving father and a caring member of the community. The only difference is this time, Mel made the unfortunate mistake of getting duped by a professional cheater. The prosecution seems to think, because Mel said price is not a concern in his first emails to Mr. Matthew before he even met Mr. Matthew, Mel agreed to committing crime. If you hear them say that one more time, please remember this. This was in Mel's second email to someone he had never met. Is it believable that it would take less than 10 minutes for a loving father to agree to commit a crime with a total stranger and endanger his daughter's future? Less than 10 minutes to do that? Price is not a concern means exactly what those words mean. What Mel explained to you right here today. Price is not a concern for someone as financially successful as Mel Smith. Third, and most important, you have to believe Mr. Matthew completely to even consider convicting Mel. The emails in the wiretap don't show you that Mel knew or agreed to the scheme. All we have is Mr. Matthew's word. Members of the jury, you must trust Mr. Matthew completely to even consider the possibility that Mel was involved in the cheating. And Mr. Matthew is someone who lied, manipulated, bribed for 15 years. He admitted to all of this right before you without hesitation. And when he was asked when some of these acts were wronged, he waffled. He said, yeah, maybe. Yeah, I guess. I got arrested for it, so I guess that's right. How is that someone you can trust? How is someone who faced 800 years in prison and got out of those 800 years by being here today someone you can trust? Mr. Matthew is a pro at cheating the system, not Mel. Mel Smith isn't a cheater. Mel is a loving father, a father who is so dedicated to his daughters. He always attends their competitions, even with his busy career. Mel is just a parent who tried to do what he thought was the best for his kid. He got Jenna what he thought was the best admissions counseling he could get her. He followed all of Mr. Matthews' advice regarding what Jenna should do, which test she should take, what doctor she should speak to. Mel even made a donation to Mr. Matthews' nonprofit because he wanted other kids to have the same opportunities as Jenna. You can say perhaps Mel was a little gullible, that Mel should have been more careful, that he shouldn't have been so quick to trust. But that doesn't make Mel Smith guilty of fraud. Members of the jury, don't do what the Smiths did and trust Pat Matthew. Pat Matthew is not someone you can trust. You should find that Mel Smith is not guilty. There is a cheater in this case, but that cheater is Pat Matthew. The defense rests, Your Honor.
Thank you, counsel.
Permission to present a rebuttal, Your Honor?
You may do so.
The defense relies heavily on the idea that Mr. Matthew is a cheater and therefore must be lying to you today. Remember that Mr. Matthew is not on trial here today. Separate Mr. Matthew's past from his present. Sure, Mr. Matthew has done a lot of illegal things over the past 15 years. He got paid to do these things. Today, Mr. Matthew has no reason to lie to you. As his agreement says, he only has to tell the truth. Mr. Matthew has already pled guilty, so there is no need for another scapegoat here for anyone except for Mr. Smith. Mr. Matthew gains nothing for lying to get Mel convicted. So why would he? In addition, remember when Mr. Smith said that Mr. Matthew became a father figure to Jenna, a close family friend, and when he said that Mr. Matthew was very involved with Jenna throughout the entire college process. Does that square with his claims of ignorance? Keep in mind also when Mr. Smith lied to you on the stand today. Think about who you want to trust. Lastly, the defense claimed that we have no evidence that shows Mr. Smith's involvement in the plan, except for Mr. Matthews' testimony. Remember the email where Mr. Smith said price is not a concern to a 6-figure offer? Remember the checks where he paid $150,000. Remember the overtly suspicious letter that he sent to College Bound. Lastly, remember the responses in that wiretap and how involved he was throughout this entire process. This evidence shows that Mr. Smith knew and intended to get Jenna into these schools that were out of her reach by any means necessary. Is there any room for reasonable doubt here? Members of the jury, that is up to you. Thank you.
Thank you, counsel. Now the jury will retire to do its deliberations. Take the evidence in with you and let us know when you have a verdict.
You're okay to start.
Okay. Can you hear me?
Yes, Your Honor.
Yes, Your Honor.
Okay, first, let me explain. If I look like I'm in a different courtroom, I had to move my computer because I was losing power. So I'm still on the bench up there. It's where I was when we started out. You guys did an excellent job. It was just uniformly good. Much better than I could have done as a 1L at Berkeley Law all those years ago. It was really good. I was really impressed. We have to do ratings, and I thought that Julia's cross-examination and her questions were sharp and right on. I thought that I liked, Nabila, the passion you brought to your closing argument was quite impressive, and you looked the jury right in the eye, and I thought that was noteworthy, and I want to give special note to those two things. As a general rule, and it's not unexpected, it's not unusual, in your examinations, cross and direct, inexperience tends to give equal weight to each point. And so you missed opportunities to nail the strongest points. You can lose the attention of the jury by just making points. I've got 20 points I want to make in this examination, and you make them and they all sound the same. That's a mistake. Make all the points, but highlight the strongest ones and listen carefully to the witness's argument and pursue it, and even reframe it. Call it something else, but you're saying the same thing, so the jury really gets that point and goes back into the jury room with that. That's not a criticism, it's something that you'll learn with experience. But I just want to say that this was very good. I was so pleased at everyone's performance, and congratulations to you. I guess our next juror should speak. Who is that?
How about Jonathan?
Okay, hi everybody. My name is Jonathan. I work in the Contra Costa Public Defender's Office, so very nice to meet all of you. And I want to say how impressed I am by how you guys did, not just as 1Ls, but in the incredibly artificial experience of talking to a computer screen where you can't see your audience, or maybe you're seeing your audience in a little box on the screen, and you can't move around, and you can't do all the things that we as trial lawyers really like to do to be able to engage the audience and to be able to develop a connection with the jury. But notwithstanding those challenges, you guys did a really, really great job. You brought passion, you brought knowledge of the facts, you brought themes to the case, and I really want to commend all of you for that. I would suggest, so as a defense attorney, we're big fans of cross-examination. We often are not putting on witnesses ourselves. We are often just trying to bring down the prosecution's case. And I think that both of the cross-examiners may have left some helpful facts on the table. And one of the things that struck me is that both of the witnesses that testified are arguably professional liars. So for example, Pat, you know, he has built an entire life around fraud, and I think that was brought out, but there's absolutely nothing that comes out of his mouth that is to be believed. And I think that theme could have been emphasized a little bit more. And on the other side, the fact that the defendant is a professional actor. His job, his life is basically convincing people that he's someone that he's not. And I think that's something that potentially could have been nicely woven into a theme on that side as well. I want to give a shout out to both of the witnesses. I thought you both were great, very well prepared, and did a really good job getting into your roles. And I think all four of the attorneys, you guys have excellent, excellent promise in your future careers. As someone who practices in the criminal justice system, I really hope that you enter the criminal justice system as attorneys, either as prosecutors or defense attorneys, because I think you'll all be great. Thanks for giving me this opportunity.
Thank you, Jonathan. How about Spencer next?
All right, folks, my name is Spencer. I'm a trial lawyer, a plaintiff's personal injury trial lawyer in San Francisco, and I run our trial competition program. And so I always say at the end of this round that I want all of you to try out for trial team. Please, please, please. I promise it will be a lot of fun. If you enjoyed this, you'll really enjoy that. So I'll keep this very brief. I'll give you one thought, which is the power of story and how it can be used in trial. I want to just talk about one way it can be used in trial. And this dovetails, I think, with what Jonathan was saying there. But I think we should look for in our direct and cross examinations the opportunity to show or tell the story of who this person is. For example, with Matthews on the direct examination, to me, the story that got told was that this guy cut a deal. I mean, we spent a lot of time on that. And that's how I started to view him, as a guy who took a deal. You know, good business move. I don't know what that means, but it's truth telling. So that's not a story we want to be telling from that side of the case, right? And so let's be conscious about how we say what we want the jury to think of when they first think of this witness, you know, back in the jury room. Oh yeah, that was the guy who cut a deal. Or, oh, that was the guy who sort of had a revelation. He realized that he was on the wrong path. It took took a lot of indictments and 800 years of threatened jail, I guess. But you want to have him branded as a person who saw the light. And that may be a challenge, but I think that's the only route to having him be credible, is that there was some reason why he is to be believed, because he changed his view of the world. Now, that's just an example. And I think that really could have been done on each of the examinations. And so I just use that, like I said, only as an example, but look for how you can take a small story and make it who your witness is. So when that person gets dredged up in the jury room, your story is how that person is perceived. Great job.
I also think that all four of you were terrific, and the two witnesses were terrific. It was so impressive to hear all six of you. My sense in terms of the advocacy is that the closing arguments on both sides were the strength, and that the cross-examinations were probably the areas that needed the most work for the future. That's not surprising. Opening or a closing argument are much more like we've done before. A cross-examination is most different from what we've done before. I agree very much with Judge Henderson about the importance in a cross-examination or direct examination of not treating every point the same. For me, if I were a juror, what I would have done is say, I don't trust either of these witnesses, but let me think about what's all the other evidence and how do I explain it. And so if I were the prosecutor, I think I'd want to spend as much time as I could on all of the other evidence, so it didn't just come down to this one person's testimony. And if I was the defense lawyer, I'd want to go through that other evidence and try to offer alternative explanations for the sake of reasonable doubt. But again, all of you were just great.
Okay, I think the jury has spoken and given you feedback. I think it's time for me to announce the winner. And remember, this is not an announcement of how the jury came out with guilty or not guilty, but the winner of the competition. And the vote was 2-1 in favor of the prosecution. It was very, very close. It was, as we've all said, it was excellent. And because it was 3 people voting, there couldn't be a tie. So it was as close as it could be without being a tie. Again, my congratulations to you. I've heard trials for 37 years before I retired, and I'm just really impressed with a 1L giving this kind of a performance tonight.